Hi friend, welcome to the Company Law Adjudication and Appeal Series. Today we are discussing Delhi ROC adjudication order in the matter of the YAL Real Estate Private Limited for the violation of section 117 of the Companies Act, that is failure to file form MGT 14 regarding filing of the special resolution. In this case, as per the MCA record, company paid up capital is 1,36,500 and revenue is nil, and company is not a holding company and subsidiary company, so that company considered as a small company. Let's see the facts of the case. Company has suo motu file application with GNL 1 for adjudication of the penalty under the provision of section 454 of the Act and rules made thereunder. The subject company has convened a EGM on 5th April 2021 to amend Memorandum of Objective by inserting new clauses therein. The subject company approved alteration of the object clause of the MOA by passing a special resolution in the said EGM pursuant to the provision of section 117 of the Companies Act. The company was required to file the special resolution passed in the EGM held on the 5th April 2021 in form MGT 14 within 30 days from the date of the meeting to the concerned ROC. The said form was required to be filed by the 4th May 2021. However, the same was filed on 7th September 2021. Hence, the subject company has made default in filing of e-form by 125 days. In terms of the provision of the section 117 subsection 1 and read with the section 454 of the Companies Act, the office has issued so-called notice to the company and officer in default. The subject company has submitted its reply in response to the so-called notice issued by the said office, wherein the application stated that default was made due to inadvertence and it has filed its e-form MGT 14 on 7th September 2021 with the Office of the Registrar of the Companies in NCAT of Delhi and Haryana, together with the additional fee, and accordingly the default has been good as on date. Let's see the relevant provision of the Act as per the section 117. A copy of the every resolution or any agreement in respect of the matters specified in subsection 3 together with the explanatory statement under section 102, if any, annexed to the notice calling the meeting in which the resolution is proposed, shall be filed with the ROC within 30 days of the passing or making thereof in such manner and with such fee as may be prescribed. And as per the subsection 2, if any company fails to file the resolution or agreement before the expiry of the specified period, then such a company shall be liable to a penalty of the 10,000 rupees, and in case of the continuing failure, with a further penalty of 100 rupees for each day after the first during which such failure continues, subject to a maximum of 2 lakhs rupees, and every officer of the company who is in default, including liquidator of the company, if any, shall be liable to penalty of the 10,000 rupees, and in case of the continuing failure, with a further penalty of the 100 rupees for each day after first during which such failure continues, subject to a maximum of 50,000 rupees. As per the section 446B, that is the imposing lesser penalty on the small company. As per this section, notwithstanding anything contained in this act, if penalty is payable for the non-compliance of any of the provision of the act by one person company or a small company and a startup company or producer company, or by any of its officer in default or any other person in respect of such company, then such company, its officer in default or any other person, as the case may be, shall be liable to a penalty which shall be not to be more than one half of the penalty as specified in the such provision, subject to a maximum of the 2 lakh rupees in case of the company and 1 lakh rupees in case of an officer who is in default or any other person, as the case may be. And in adjudication, the applicant company and its officer who has made the default in complying the provision of the section 117 subsection 1 for not filing e-form MGT 14 within 30 days of the passing of the resolution are now liable for penalties under section 170 subsection 2 of the Act for the duration of the delay, which extends from 4th May 2021 to 6th September 2021, that is for 125 days. Now in exercise of the power by notification dated 24th March 2015, and having considered the reply submitted to the notice, in response to the notice, ROC imposed the penalty on the company and its officer in default for violation of section 117 subsection 1 of the Act, subject to provision of the section 446B of the Act, read with the section 2 clause 85, that is the small company of the Companies Act. As the company fulfills the requirement of the small company, and penalty imposed for 125 days, this is the calculation of the penalty, 10,000 plus 100 rupees per day multiplied by 125 days is equal to 22,500, and on the both director, that is also imposed penalty of the 22,500, and penalty imposed to be adjudication officer by applying the provision of section 446 B of the Companies Act, that is the half of the penalty, that is 1100 to 250 on the company, and on 11,000 to 250 on both of the directors who is in default. In order, the company and its director are directed to pay the penalty amount as per the above calculation. In case of the director, such amount is required to be paid out of their own funds. The company and its director are hereby directed to rectify the default immediately from the date of the receipt of the copy of this order, and pay the amount of penalty through online by using the MCA website in favor of the pay and account officer within 90 days of receipt of this order, and intimate this office with proof of the penalty paid. Appeal, if any prefer, then file appeal within the 60 days from the date of the receipt of this order in form ADJ, setting for the grounds of the appeal and accompanied by the certified copy of the order. Thank you so much for watching this update.